minutes for rebuttal. This is an appeal of an order denying certification of a class of Medicaid recipients that were denied benefits to which they were legally entitled. The Medicaid Act contemplates that Medicaid nursing home recipients would contribute to the expense of their nursing home by paying a copay depending on the amount of that individual's income and the legally authorized deductions. The copay is calculated by taking the amount of the individual's income, making those lawfully authorized deductions, which are pre-eligibility medical expenses. Those amount that are deducted is the amount that the recipient is allowed to keep to pay off those pre-eligibility nursing home bills or pre-eligibility Medicaid expenses.
Now, before you get too deep into it, sort of from the 40,000-foot level, your brief mentioned that there are 5 cases before us that are in the same area. As I look at it, 3 of them are sort of an unpromulgated rule challenge that don't seem to be determinative in any way or form of what's going on here today. 2 of them, it looks like, are traveling together per the party's motion. Mm-hmm. One is Ms. Goodwin's appeal out of the administrative action, which it looks like may or may not interact with this case. If you win, then this case, it would seem, would go forward. If she would lose on that, then maybe there would be standing or adequate class representative type problems. Is that?
Yes, so there's 2 types of cases that are pending before this court other than this one. Let me begin by saying that, of course, this case is limited to the class certification issue, and as I'll get into in the argument, regardless of how any of these other companion appeals are decided, this order should be reversed for the reasons that I'll get into. But so there's 3 cases pending, Looney, Sanders, and Newman, and those cases involve recipients who applied for Medicaid and were eligible for Medicaid after the amendment to the state plan in 2012. We say in that case that the 2012 amendment to the state plan does not have the force of law. We cite cases that support that proposition, and therefore the 3-month limitation that the state has implemented after the fact in an attempt to fix this problem doesn't apply to any of these individuals who applied for and were found eligible for Medicaid before the rule was actually properly adopted on August 12, 2015. Goodwin's appeal, Ms. Goodwin's administrative appeal is a little bit different. She applied and was found eligible for Medicaid before any attempt to fix the problem by amending the state plan. And so her appeal is from a final order that says she's not entitled to anything based on the agency's interpretation of the state plan. And so there may be instances where, depending on how the outcomes of those cases, that may impact ultimately what happens when we get to the merits of the cause of action in the class action case, but they don't at all affect the determination of whether this class should be certified. Does that, okay. So the Medicaid Act contemplates
it would just seem, I guess going back, it would just seem that if on the merits of her appeal, looking at her own case, that if she were to lose that, then under SOSA, her ability to represent the class, there would be a standing problem under SOSA, and her ability to represent the class as an adequate representative, be it because of her own fact situations or the representation, would be in a different place than what the circuit.
Yeah, I understand that question. There actually, as a practical matter, is no way that Goodwin can lose her administrative appeal. The administrative appeal, like I said, was from a final order that found that she wasn't entitled to any benefits because they don't make any deductions for pre-eligibility unpaid nursing home expenses. The state has since then tried to make an after-the-fact fix, and they have paid a portion of her Medicaid expenses for using that 3-month limitation that they've later deducted and later adopted in a rule in 2015, but by amending the state plan in 2012. So under all circumstances, Goodwin has to win that administrative appeal because that final order can't stand when the state has already admitted that it would pay her that 3-month limitation. So that being the case, she would not lose her standing because, first of all, when she goes back down, the very heart of our claims is that she is not entitled to that 3-month, or she's not limited to that 3-month deduction that the state has later imposed, because number one, it doesn't apply retroactively, and number two, it doesn't have the force of law until a properly promulgated rule is in place. So she would not lose her standing because there's other claims that need to be decided. Also, we don't know of any case that says if you win your at least a portion of your case, that you're going to lose standing to bring your class certification claim and you're not adequate as a class representative. She would have been vindicated in at least a portion of her claim, depending on how that case comes out, which deals with the issue in that case is whether, one of the issues in that case is whether the state plan can be applied to her since she applied for benefits long before that state plan amendment was ever even in effect.
Judge Osterhaus asked about SOSA. Does the Judge Dempsey's order have sufficient factual findings under SOSA? I know you disagree with some of the legal conclusions that Judge Dempsey made, but are there enough factual findings for us to find that that order is supported by competent substantial evidence?
Absolutely not. First of all, we don't believe that any of the fact findings or any of the findings made by Judge Dempsey in the order below are in fact findings. If you look at the reasons that she denied the order, she gave 4 reasons for saying that the class certification requirements weren't satisfied. When you look at the reasoning she gave, you can tell that she conflated class certification criteria with a determination of the merits of a cause of action, which is directly contrary to SOSA's direction that you are not to consider whether a plaintiff is right or wrong on their substantive causes of action when determining whether a class should be certified. And I'll give you examples of that. She gave, like I said, she found 4 reasons why class certification wasn't satisfied. The first one was that the class was overbroad. She said the class was overbroad because it would include people who are not harmed, because their nursing home benefits may have been paid through retroactive eligibility. First and foremost, a class is not overbroad simply because someone may not be damaged. But even more importantly, under our class definition, a person who has had their nursing home expenses paid through retroactive eligibility has no pre-eligibility nursing home expenses and would not be in the class at all. So that's a non-issue. That's a finding that is it's not a finding of fact, but it's a finding that is completely irrelevant to the class in this case. She also ruled that the class was overbroad because it included people who may have a 0 PRA, but we made clear in our filings in the circuit court, as well as repeatedly during the hearing on class certification, that this class would include people who actually had to pay a copay. And the state has filtered out those people who had to pay a copay, so that's an easily ascertainable element of the class to determine who actually had to pay a copay. So for those reasons, her overbreadth analysis was incorrect. She also found that the class was not ascertainable because she would have to make individualized fact findings, and respectfully, every single reason she gave for that is incorrect, merits determination. A class is ascertainable if you can identify class members on an objectively manageable basis, and you don't have to go back to the court to keep making individualized determinations with respect to every class member. The court in this case, the trial court, gave 5 reasons for finding the class wasn't ascertainable, none of which actually are relevant here, and all of which go to the merits of a cause of action. The first was that she would have to make an individualized determination as to whether Medicaid recipients were still receiving benefits. Well, whether a Medicaid recipient is still receiving benefits is not a relevant determination to whether this class should be certified.
How does that interact with exhaustion of administrative remedies idea? As I understand your class, there may be folks who never presented their claim to DCF at all, those who did and were rejected. They exhausted their administrative remedies but were rejected.
try again, and we'll add another 30 seconds to her time, please.
The exhaustion question,
Hold on a second, counsel. So,
you can hear me if I just talk like this, right?
yes, and you can probably get closer without triggering
Okay.
that. Let's try that.
Okay. The exhaustion.
But it seems like, anyway, it seems like that there's 3 or 4 different categories that the folks who are included within your class could fall into. Some who didn't exhaust their administrative remedies, some who did, some who maybe did, and exercised their 30-day period to appeal to this court, and we don't have a record of it, but perhaps they did, I don't know. But you have all this pool of people who I guess now have their claims resurrected vis-a-vis a class action because of the class definition, or?
Right. Well, there's 2 answers to that question that are sort of separate. Number one, of course, the state has not raised an exhaustion argument in their brief, but if the court would like supplemental briefing, I can provide it on this. The law is clear that when you bring a class action based on something like this, where an agency has a uniform policy that it's uniformly applying in violation of the law, it's not a requirement that everyone exhaust their administrative remedies. As long as one person has went through the process and it was denied, and you know that's going to be done over and over again, there's no requirement that they exhaust their administrative remedies.
Even for those who are in and out of the program in 2008?
That's correct. Absolutely. Yes. The statute of limitations period begins in 2008. The claims are for a violation of state law, and they would absolutely, under that law, be able to bring these claims now. It would actually be
Even if they had already brought them back then?
I'm sorry?
I mean, some pool of people may have already brought their claims.
The only people that have already brought them are, we know Ms. Goodwin brought hers, which gave her standing to bring this class certification action, and then you have Looney, Newman, and Sanders, who also brought their claims after the 2012 state plan amendment was in effect. But this just goes to show that out of thousands of people, that we know from 2008 to 2012, there were at least 154,000 people in the system receiving Medicaid benefits. All of these people, they're elderly, vulnerable, incapacitated citizens who are in nursing homes, may not know that they can bring, that their copays are even be calculating incorrectly. And that's exactly why a class action exists. It exists so that we can take all of these pool of people who have been affected by an improper uniform policy and remedy the error for them. Getting back to ascertainability, like I mentioned, the class is ascertainable if it can be ascertained. Members can be ascertained on objectively identifiable, manageable criteria, and that's not at all what the trial court applied here. She said that one example was that she would have to make individualized findings as to whether someone was still in the Medicaid system. That's not anything that's relevant to this class. Our class includes those who are still in the system and those who were in the system as of 2008 during the class period. The reason she made that finding is because she accepted the state's argument on the merits that it can only provide prospective relief, which is directly contrary to federal and state law that says that when you miscalculate a PRA, you have to make corrective payments. The second ground that she said for ascertainability is that she would have to make individualized determinations as to the amount of each individual's pre-eligibility nursing home expenses. That's not true. The amount of someone's pre-eligibility unpaid nursing home expenses goes to a damages question. That's not something that's necessary to ascertain the members of the class. Ascertaining the members of the class is done by looking at the nursing home records, which are easily ascertainable. They'll say these people had these expenses that weren't paid at this time, and we can pull that out to find out who would be a member of the class. Damages at that stage is irrelevant. The third reason she gave is that it would require individualized determination as to whether they incurred expenses 3 months prior to the date they applied for Medicaid. That, of course, assumes the state's position that the 3-month limitation on the PRA deduction is lawful, which we contend it is not, for all of the reasons that will be argued below, and that is also raised in the companion administrative appeals as to why that 3-month limitation can't be applied. So the court just jumped to the merits without any of it being teed up in making that ruling. The fourth determination as to who is in a penalty period. Well, if you're in a penalty period, you're not eligible for Medicaid yet. They find that once you're through the Medicaid period, once you're through the penalty period, then you're eligible for Medicaid. So those people wouldn't be into the class unless they ultimately are found to be eligible for Medicaid. They have unpaid pre-eligibility nursing home expenses at the date the person became eligible for Medicaid and had a positive copay.
Counsel, your time's expired. I'll allow one more minute. I assume you want a rebuttal.
I do want rebuttal, but I think I lost several minutes with this.
Well, I don't think you did lose 2 minutes, but we'll make it 2 minutes for both sides.
Okay, well, I'd like to save the rest for rebuttal, so I'll close this by saying, if you look at every single criteria that the trial court applied in saying that 4 class certification criteria were not satisfied, those are a direct contravention to SOSA's direction that you do not look at the merits of the cause of action. That's all she did. She didn't make fact findings. She didn't apply just a class certification criteria. She went to the merits, and that's something that you cannot do, and that's why the order should be reversed. And I'll offer this.
Thanks. It seemed like a couple of minutes when that noise was made. I know. Sorry about that. Well, it didn't seem to be a problem at that. It's up to you.
May it please the court, Ashley Davis on behalf of the appellees. At this point, the only one ignoring SOSA is the plaintiff. Supreme Court in SOSA clearly defined the standard of review as abuse of discretion, and it reversed the RCCA's opinion to expect the court to weigh the evidence instead of giving deference to the trial court's findings. The plaintiff here merely argues for motion for certification and wants this court to hold that the findings were just wrong rather than unsupported. Plaintiff did not show that abuse of discretion, and the trial court's findings were supported by competent substantial evidence, and there was no clear legal error. Therefore, the trial court's order denying class certification should be affirmed.
Well, under SOSA, doesn't the order, Judge Dempsey's order, didn't it need to have specific factual findings? I mean, she reviewed and stated in the hearing that she reviewed the various depositions and affidavits and those kind of things, and I certainly take her at her word on that. But didn't she need to say, I find, based on Nathan Lewis's affidavit or Siobhan Harris's affidavit, that this is the case, and make specific factual findings as opposed to these more general legal conclusions?
I don't find that they're general legal conclusions. I think that they're factual findings. They just don't contain the specificity that you're asking about. And SOSA doesn't require that level of specificity to outline every single point in the record or any testimony that supports the finding of fact. She weighed the evidence, and she came to the proper conclusion that class certification should be denied. And there were several reasons why the class is overbroad. And all of those reasons amount to a substantial number of individuals, which would lead you to believe that numerosity might actually not be met. They say that there are hundreds of thousands of people in the Medicaid system, but that doesn't, once you factor out those with zero PRA, those who had their nursing home bills paid by retroactive eligibility, those who are deceased and ineligible, you have not much of a class left. You might not even be able to meet numerosity in fact. I think plaintiff has conceded that the class is at least overbroad for at least 2 subsets of people, those with positive PRA, those with zero PRA, and those whose nursing home bills were paid with retroactive eligibility.
But isn't she saying that they effectively tweaked that definition along the way?
They never changed the definition. They didn't tweak the definition, and as the definition is written for the motion for class certification and the renewed motion for class certification, it does not exclude those with a zero PRA, for example. That limitation on this class only includes those with a positive PRA. That was something that was put in the proposed order on the renewed motion for class certification. It wasn't part of the motion that was argued. So as
And some overbreadth is allowable, isn't it?
Not to the extent that, of the overbreadth that is involved here. It's not just some of the class members. Those with zero PRA represent 17% of those who are receiving nursing home care benefits in the system at any one time. Also, those who have their bills paid by retroactive eligibility, that's about 95% of those who had nursing home bills in their files. And even Ms. Goodwin herself,
Are you saying 95% of them got all of their unpaid nursing home bills, pre-expense nursing home bills paid? So that their class is only defined by 5% of the definition?
so the 95% comes from the case review that was done in 2014 of DCF recalculation of PRAs. And they looked back and they found, I think, maybe 29 people who had nursing home bills in their file, and 28 of those had all of those nursing home bills paid by retroactive eligibility. So that's where that percentage comes in, and that's a substantial portion. And it's not just that there should be nursing home records in the files, even though there was an exclusion of nursing home records in the deduction. And that's because you can have all of your nursing home bills paid through this retroactive eligibility. So it was an independent incentive for an applicant to submit, here are my nursing home bills, please take them into consideration. So it's not like, appellant isn't correct that people wouldn't have submitted their nursing home records because it wasn't subject to a deduction. There was an independent reason why you should have been incentivized to submit those records, and it was because they could be paid through retroactive eligibility. And to the extent that there is any evidence in the record, 95% of those people, that's what happened.
Well, if you take out 95%, that's still, what, 750 or so people? I mean, certainly you wouldn't expect all of them to file individual claims. It would be much more convenient to have a class of 750, right?
Well, then you have that the nursing home bill can't be incurred during a penalty period, and then the nursing home bill has to be incurred outside of the 3-month limitation. That 3-month limitation has always been ruled, and it's always applied to all medical expenses. I don't know exactly what the argument is about this unpromulgated rule challenge to the 3-month limit. The 3-month limit has always been ruled. It's whether the nursing home expenses should have been deducted and not excluded from the deduction. Also, there is a significant amount of individual inquiry involved in ascertaining who is a member of the class. It's not a damages issue. It's basic understanding of who is in or out of that class, who has even been injured for standing. In order to find those people with a zero PRA or with a positive PRA, you have to engage in that 10-factor analysis to decide if the lack of a nursing home bill deduction would have even affected them. Then you pile on the nursing home bills could have been paid by retroactive eligibility, the class keeps disappearing, but all of those inquiries are individualized, and that's what defeats ascertainability. And plaintiff doesn't particularly argue that it doesn't involve an individualized inquiry. She says, well, that's for damages determination. No, it's for liability. It's for basic injury. And she says, well, the agencies engage in this analysis quite frequently, and it's a lot easier than they would lead this court, that they have led this court to believe. But the sheer fact that the inquiry is individualized will defeat ascertainability. And it's hard to understand how plaintiff is going to be able to objectively, readily, and feasibly ascertain the members of the class, those who, for one part, have a positive PRA.
Have you said that they can get that from the nursing homes?
Well, the nursing home bills of who has an unpaid nursing home bill, that's not indicative of injury to the class, because those nursing home bills could have been paid by, again, retroactive eligibility. So just having a nursing home bill doesn't mean that you're a member of the class. And also, it's subject to an individualized defense of the nursing home bill may be
Has a rule been promulgated yet on that, or are you operating, is DCF operating under the state plan, or?
Well, again, as to the 3-month limit that they're always arguing about, that's always been a rule. The removal of the exclusion for nursing home rooms and adoption, I believe that's effective in rule now. But the 3-month limit is something that's always been in rule. And that helps go to why plaintiff isn't typically
number one to keep in mind absolutely is that everything she said assumes the merits of the cause of action are true. That has not been decided, and that is not to be decided at the class certification stage. Whether the 3-month limitation they imposed on deduction with the amendment of the state plan is even lawful without the promulgated rule that wasn't done until 2015, that's an issue to be decided. We say that it doesn't have the force of law. We also say it can't be applied retroactively. So everything you say about this 3-month retroactive limitation that they've done is not, that's a merits question that has not anything to do with class certification. She spoke a lot about prospective relief and that they can only provide prospective relief. That assumes the state's argument is correct. If you look at the state regulation and the federal regulation we cited in our brief, it shows that corrective payments must be made back to the date that the miscalculation was made. So their statement that prospective relief is all that is required not only is wrong, but is a merits determination. She said that 5% didn't receive benefits. That's absolutely false. That comes from a case study they did, a quality assurance report they did on 417 randomly selected cases where they tried to figure out whether they were doing it correctly. 417 out of what we know is more than 150,000 people who receive nursing home expenses. That's it. That's not a correct number. It's limited to a random selection. It has no bearing on anything here except to show that the state had a very high error rate in doing that. The 3-month limitation has not become the rule. Let's see. She says the question about going to the nursing home, that's what federal law requires. Federal law contemplates a payment to provider approach, and that's why the court said that we weren't an adequate representative. However, asking the court to do or suggesting that the court do what the law requires, it does not make you an adequate representative. If the court on the merits decides later, hey, well, maybe these should go to recipients, then that's something the court decides. That's not anything we take issue with. We were just saying this is what federal law requires. That doesn't make us inadequate. The fact that people are deceased doesn't mean they're not entitled to benefits. Nathan Lewis, their own witness, testified to that. Shanta Jones, their witness, testified that when they improperly inflate co-pays, they pay those to the nursing homes, and then the nursing home reimburses the recipient. So everything they said either is a merits determination that is not, that puts the cart before the horse, accepts that everything they're saying is right, which we highly dispute.
All right. It's 1:30 in the red. I think we've covered all the time allotted. Thank you for your argument.
All
Court is
rise.
in recess.